I was talking about the, where the, if you can find an assignment that was entered after the filing of the lawsuit. And I just wanted to say that there was one Superior Court case that just came out which in maybe one sentence may have indicated that you can't argue that just because the assignment was filed before the complaint was, the assignment was entered after the complaint was filed, it may have indicated in one sentence that that may not be true anymore, that that's an improper plaintiff, but I tend to believe that that's not the focus of that Superior Court decision, which we're going to talk about in a little bit anyway. So, but there is some concern now that that's not anymore a legitimate argument. But for our purposes, it is. And your purposes of pursuing that, it is. Also, there's one other thing with regard to the simplest type of argument to make and looking at the assignment is make sure that the plaintiff, well, actually, this doesn't, make sure that the name on the assignment is actually the name that's listed as the plaintiff. And because sometimes they're different, and I know of one attorney who's filed objections because the plaintiff's name was Wells Fargo of California, and the assignee's name was Wells Fargo of Indiana, or something like that, which actually are, you can find out, they're two different, they would be two different corporations. So if you look very closely to make sure that in actuality the assignee on the assignment paper is really the name of the plaintiff, that could be an argument as well. The second thing I usually look at then after I look to see about when the assignment occurred and the name, make sure the names conform to the plaintiff, is making sure that the chain of assignments, the chain of title, is continuous, and to make sure that in fact you can see how the plaintiff, that there really is an argument how the plaintiff at the time of the filing of the complaint had really acquired that assignment of the mortgage. And right now I don't know of any litigation of that case. I don't know of any court cases in Pennsylvania about this, and by the way, well, but right now I just filed an appeal to the Superior Court where it was clear from looking at the documents that there was no continuous chain of title, of assignment, no continuous chain, so that the plaintiff, in my particular case, I'm arguing still doesn't actually own a valid assignment of the mortgage because of the manner in which the assignments were done. I'm arguing that there never was a proper ownership interest in the current plaintiff. And obviously then you have to look by, to just make sure that A goes to B, B goes to C, C goes to D, and there could be several assignments. And if it isn't A to B, B to C, C to D, then you can argue that they don't have the plaintiff does not have the proper standing. And there's also, by the way, when you raise this as an affirmative defense in new matter to a foreclosure complaint, you can assert lack of standing. You can assert lack of capacity. That's a preliminary objection, but you can also argue that as an affirmative defense, lack of capacity to sue. And also you can argue that the plaintiff is not the real party of interest, which violates Pennsylvania Rule of Procedure 2002. So those are three different ways to attack the validity of the plaintiff under, you raise the legal terms that you use to challenge that.
Do hot docs pleadings have these defenses in them? Do we know?
Yes.
Or you can go to hot docs and do it that way. So let's see, what else? Now, okay, so the question of, if you are lucky enough that you get the complaint, your client comes with a complaint before there's a default judgment, then these arguments are fine to make, and you can force the plaintiff to spend a great amount of time and effort, and possibly futile time and effort, to prove that they're the proper plaintiff. There are no
I'm sorry, I don't want to interrupt you.
No, go. Please interrupt.
Can you talk, or are you planning to talk at all about the Act 91 notice and who sent that out versus who filed
Okay.
the complaint?
Yeah, I was, and that's a good time to do that. One of the arguments that you were saying is that a couple people in our state have used this lack of proper plaintiff argument to also add another argument on top of that as an affirmative defense that has to do with the Act 91 notice. Because Act 91, by both statute and regulation, requires that the mortgagee send out the notice, and the term is mortgagee. So, therefore, if you believe that you can make an argument that the entity which sent out the Act 91 notice was not the actual holder of an assignment properly on the date that the notice was sent out, then the argument can also be made that the Act 91 notice is invalid, because the regulations and the statute, and by the way, the regulations also refer to the form notice now, and I believe the regulations require that the form notice be used, and the notice itself says mortgagee. So the argument is that if the entity which sent out the Act 91 notice sometimes is the original mortgagee, but by the time it gets to court you have the assignee filing the lawsuit, then you can say, well, the mortgagee, the mortgagee, on the date that the lawsuit was filed, was not the proper. The mortgagee on the day the lawsuit was filed, did not actually send out the Act 91 notice, and therefore the Act 91 notice is invalid. And because the courts have already held that failure to comply with Act 91 is a jurisdictional, deprives the court of jurisdiction to proceed with the case, and that's a powerful argument that can be made. There's a big but, and that is that a pro se litigant, and I am concerned about these pro se litigants who are resulting in a few now bad Superior Court cases, but there was a pro se litigant who argued another mistake in the Act 91 notice. They argued that the servicer was either wrong, that the name of the servicer was either wrong, or else that it was not, or I can't remember now, something to do with the name of the servicer on the Act 91 notice was wrong, and they argued that violated Act 91, and that therefore the whole foreclosure lawsuit was improper, and the Superior Court said no, essentially we're going to overlook that. That's a problem case. I don't know if it was reported. I don't know if it was reported, but my hope. But the court in that case did not mention or address the issue of jurisdiction, and because there are a couple of Superior Court cases that are quite clear that Act 91 is imposes jurisdictional requirements on the lawsuit, that argument about the jurisdictional effect of a defective Act 91 notice could still be raised and hopefully prevail. But go on.
Is there anything black letter as yet that holds that a mortgagee who has entered into a servicing contract with a servicer, and it's the servicer that gives the Act 91 notice, is there anything that says that that's an invalid Act 91 notice?
I don't.
The question was,
I'm sorry,
is
yeah.
there any decision that holds that an Act 91 notice in the name of the servicer as opposed to the name of the owner of the loan would be an invalid Act 91? And I don't think there is anything. And I have to say that I'm doubtful that a court would find that. I know that the statute requires that the notice be in the name of the mortgagee, but it is so accepted in the mortgage world that it's the servicer who is really the party who deals with the loan. We could barely get the courts to say that it has to be the owner of the loan who's the plaintiff in a foreclosure, let alone the name on the Act 91. So I'd be surprised if a court reaches that, but it doesn't prevent us from making the argument in our cases.
And the only place where I think that might possibly go somewhere is if the servicer sends the notice, but somehow in there identifies the mortgagee and identifies the mortgagee as incorrectly as an entity that as of the date that was sent out was not in fact the mortgagee.
And as a matter of fact, actually, I have a case now where, in fact, the Act 91 notice, which has only the name of the servicer, the alleged servicer on it, and the phone number and the address of the alleged servicer. It turns out that servicer hasn't been in existence for several years. And I do intend to assert exactly that's therefore a faulty. But I agree that might be the only way.
And that's very different. I mean, in that case, the company to whom the homeowner is supposed to make her payments has been wrongly identified in the Act 91 notice. And is more relevant to our clients. Where do I got to send this money if I can get caught up under this notice than who the actual owner is?
With regard to just one more thing with regard to looking at the assignments carefully and figuring out if there are any defects at all in who the name compared to the named plaintiff. There is one Superior Court case which does hold that if you fix a problem with who the named plaintiff is that arose as of the day of, if there was a clear problem with who the plaintiff was as of the day of the filing of the lawsuit, but then before the judgment was entered, the problem was fixed by the plaintiff. For instance, the Superior Court case dealt with where an ejectment action had been filed before the deed had been transferred to the new owner after a sheriff's sale. But while the case was pending, that deed was actually transferred to the new owner, the plaintiff. And so the plaintiff was arguing, well, see, the problem was corrected after we filed the lawsuit, but before the judge made the decision, so therefore there's no problem anymore. The Superior Court held, no, you can't correct the problem after the day of the filing of the lawsuit because the law requires that the day of the lawsuit, as of the day of the lawsuit, there must be a valid cause of action. And so that was
Is Long you're speaking?
Yeah, Wells Fargo versus Long. So that still is in effect that the analogy would be used then for this assignment and cure of the assignment before the case runs out.
I mean, you're allowed to say that was your.
Okay, it was my case. So, thank you. So, and that was before I understood anything about these security things or anything. There is a problem. There is a question on assignments. There are two questions which I'm aware of are outstanding. One is whether an assignment can be valid if it's an oral assignment. And from my research, and I don't know if you agree, that is unclear in Pennsylvania. Although there are other states where the statutes require written assignments. It used to be up until about 2 weeks ago, at least. It was unclear whether or not the day that you look to decide. At least some people argued. Usually the lenders would argue that it's unclear that the date that an assignment is effective would be the date that the assignment was written, if it was a written assignment, or the date that the assignment is recorded. And from usually from legal services perspectives, it's beneficial to our clients, and also it just makes much greater sense under the law that the assignment is effective as of the day it was written, not of the day as the day of the recorded. Actually, Pennsylvania law does not even require that an assignment be recorded, and there are very, very old cases that do say that. But which I was relying on until a couple weeks ago in this otherwise not good opinion in the Superior Court case of Mallory. The Superior Court held very clearly that an assignment is effective as of the date it was written and not the day it was recorded. So if that were to come up. But there are, go on.
Well, just on that minor point, in the Pennsylvania criminal statutes, there's a provision that requires assignments to be written. In the pleading rules, there's rules that say if the cause of action relies on writing, the writing needs to be attached. Right? So if you're not going to record it and make reference to a recorded assignment, there still exists a preliminary objection based on the fact that there's a requirement that assignments be in writing, and that the pleading rules require you to attach the writing.
Right, and I said before that, right, if they don't, if the assignment has not, well.
Can people in the back hear questions from up front? Could you hear that? Okay, thank you.
Yeah, if there is a written assignment, but it hasn't been recorded, and your client comes in with a complaint and it's not been attached, then yes, file your preliminary objection and say, we want to see, you have an obligation to attach that assignment. That's always there as long as there hasn't been a default judgment entered.
Do you think now's the time to talk about?
Well, I just want to say one more thing, and then about, we have seen assignments that say this, because people started around the country, started to say, hey, you can't continue with an assignment when it wasn't executed before the day that you filed the lawsuit. So all of a sudden we've seen assignments that say this assignment the assignment has a date that's after the day of the lawsuit, but it says this assignment is effective, retroactive to a zillion years before the day of the lawsuit. And the question then is, that has to be dealt with, is whether there's such a thing as a retroactive assignment that's considered to be effective as of the retroactive date. There are no cases in Pennsylvania about that yet, at least appellate court cases. I don't know if anybody's litigated that yet. There are a few cases, and by the way, the case law that you can look at, which is, I know in, I think you have Beth put some of those out-of-state cases in the materials. Primarily Ohio, New York, and some from California, but Ohio and New York have judicial foreclosure. Many states do not have, as we do, as Pennsylvania has, the obligation to sue for foreclosure, and thank goodness we do. But in any event, there's cases are primarily from Ohio and New York. But there are cases from New York that have held that these entities called retroactive assignments are BS, and they're very strong, so hopefully that would be the outcome here. Would you want to, there is so these are all things you can raise pretty easily as affirmative defenses to your foreclosure complaint, or in POs as well. Some of the technical parts of it, like failure to attach the right documents, that's POs, and then the rest of it are affirmative defenses. The problem, it becomes much more problematic, very problematic, if the case comes to you after there's a default judgment in foreclosure about this issue of assignment. And so there was a Superior Court case that just came out, and
I actually want to pause
Okay.
for a couple of minutes to talk about the why it matters piece of who owns the loan and why it matters, because dealing with a default judgment was, in my mind and my practice, one of the reasons why I wanted to grab onto this issue. And I think of there being as 4 or 5 reasons why I want to grab onto this issue in a case. One of them has been, and until a couple weeks ago when CLS had a bad Superior Court decision in one of our cases, that one of the reasons for this is grounds for a motion to strike. Many of our clients come to us after a judgment in default has already been entered, and we want to open it or strike it. It used to be my experience that I could get judgments opened even if a significant amount of time had passed, if I had a strong enough case, if there was horrible predatory lending issues or a truth in lending rescission. But we started to get bad court decisions on those petitions to open. So looking for grounds to strike, which doesn't have a time limit, you can file it months and months after the judgment's been entered if you've got a grounds to strike, and it doesn't matter the amount of time that's passed, as long as the deficiency is on the face of the record. And the failure to have an assignment of mortgage, to even avere it in the complaint, because the foreclosure mills have become really sloppy, or maybe they always were, they're very sloppy about avering what seemed to us to be the basic requirements for a foreclosure action. Who made the loan, and to whom was it assigned, and who owns it now, and that full chain of assignments in between. Seemed to us like a really good grounds to strike a judgment, and we'd succeeded in many cases, but it was denied in this case that we're talking about now, and we took it up to Superior Court thinking because other courts across the country had found that this was grounds to toss a foreclosure case out, that it would be grounds to strike the judgment in Pennsylvania. Well, the Superior Court disagreed. And Peter is going to talk about that particular case in a minute. So that's one reason to go after this issue, to open up, to strike a default judgment. But other issues at play, if you catch the case before judgment's been entered and you're defending it, maybe you've got some claims that you want to raise, defenses and counterclaims, that it was a horrible predatory loan, the lender lied to the homeowner about the terms of the loan. There are several problems with that. But one problem could be that the current owner is a holder in due course, and none of the claims that could have been raised against the originator of the loan can be raised against the current owner of the loan. Well, if the loan was acquired by the current owner after the loan was in default, they can't raise holder in due course defense to any of these claims you would have against the original lender. And if they have messed up their chain of assignment so that they don't produce an assignment until the foreclosure is filed, well, by definition, the loan's now in default, and their messed up chain of assignments could actually help you establish that they're not a holder in due course. But the other issue is that to be a holder in due course, you got to be a holder to start with, and these are definitions under the UCC that I won't go into, but if they haven't, the originator and then all of these subsequent assignees haven't taken the time to make sure that the transfers comply with the UCC, then they're not a holder officially, let alone a holder in due course. So you can get around any claim that they might make that they're a holder in due course based on this issue. It also, to me, is a way to raise a legitimate defense to the foreclosure to get you some more time to work out some kind of arrangement. If it's an FHA loan, it gives you more time to try to get one of those FHA foreclosure resolutions. If it's covered by HAMP, it gives you more time to get a HAMP modification, and any other of the foreclosure avoidance tools that are out there. It's a placeholder. It's a legitimate defense to be raised as a placeholder, even when it looks like there aren't any other defenses. In some cases where there's serious predatory lending claims, and this is a horrible loan with a really high interest rate, and even a modification under HAMP isn't going to get you where your client deserves to be or where they need to be because of the affordability issue, because not everybody can afford to pay 31% of their income towards the house payment. If you need more than what these standard modification programs give you, then this issue of a messed up chain of ownership might give you the leverage that you need, in addition to, say, predatory lending claims or truth in lending rescission claims, to get an even better outcome for your client. And we have, in some of our cases, gotten really good outcomes for our clients' loan. While there are some cases that are so awful, and this, I guess, is my last category, some cases that are so awful that what you want to do is make the loan go away completely. Those are rare, but they're out there, and sometimes the grounds for making the loan go away completely is that this whole chain of assignments is so fouled up that the lender, the company that says they own the loan really doesn't. I mean, this is not a smokescreen or a, you know, you're not raising it for any of these other reasons, but you may have come upon a case where the problem is so profound that this loan needs to go away completely. And I've had a couple of those cases over the years. One of them was that there was a contractor who was involved in originating these loans. The contractor had been given permission by a licensed mortgage broker to basically originate the loans. And in a couple of the cases, it was the contractor who actually put up the money. And then, pretending to be the licensed mortgage broker and lender, sold the loan to KeyBank and gave KeyBank its own account number as the place to deposit the money. So KeyBank thinks it's buying a loan from this licensed a lender who's licensed in Pennsylvania, but because the licensed lender had given permission to this contractor to act like it's an employee of this lender, the contractor was able to get the money not from the original lender but from the subsequent purchaser. I mean, this is how sloppy this whole business had become. And so the KeyBank, as the purchaser of the loan, sends the money to the contractor's account. And then, you know, from my point of view, there was never a real loan because there was never a licensed lender involved. And so the foreclosure plaintiff, in my mind, owned nothing. And I can rely on this need to have the note properly assigned and the mortgage properly assigned to explain to the judge why this plaintiff should be denied foreclosure altogether. So I think those were about 5 different reasons for wanting to understand this issue and wanting to be able to use it in your cases.
So the question becomes how and when can you use it? And we were, just as Beth said, dealt a pretty bad blow with this decision. It's U.S. Bank N.A. versus Mallory. M-A-L-L-O-R-Y. It just came down on September 14th. We are probably going to be requesting a rehearing en banc of this, and we're trying to determine what to do with this and where to go. So this decision maybe will not stand, but it's there right now, and it's either a little bit bad or very bad, depending on what was really meant by it.
But keep in mind, as we're discussing this case, that it doesn't say anything about your ability to raise this issue
let's talk about what's in it.
as a defense to the foreclosure. I don't want it to seem worse than it really is. If you catch a case before there's a judgment entered, the other side may cite this. It's not that bad.
The case came up in the context of a petition to strike and a petition to open a default judgment. And as Beth said, it was brought in that way because the client came to us after judgment had been entered.
Wasn't this after a sheriff sale too?
No, there was no
this
sheriff
wasn't
sale.
Okay.
In this case, the plaintiff pleaded that they were the legal owner of the mortgage and were in the process of perfecting their assignment. And they didn't attach anything. They could not refer to a recorded assignment because no assignment had yet been recorded. So they violated the pleading, several rules here. One is the general Pennsylvania Rule of Civil Proceeding that says that if an action is based on a writing, you have to either attach the writing or explain the absence of the writing and describe its substance. They tried to, often the plaintiffs refer to something that is about to be recorded as if it has been recorded and think that that satisfies the requirement that you can refer to it in lieu of attaching it. And they tried some version of that here. The other rule is the mortgage foreclosure rule that requires that you plead the date and parties to a mortgage, and if there's an assignment, the date, place of recording, and parties to an assignment. And they did not plead that because there had not yet been an assignment. They thirdly didn't make any specific averments as to the basis for their claim that they were the legal owner of the mortgage. They just said it as if that was enough, and then said that they were gonna perfect that through an assignment, but didn't describe how it was that before that assignment existed, they somehow came to have the status of legal owner of the mortgage. We thought that all of those were perfectly good grounds to strike the judgment as defective, because the complaint was defective on its face. And the Superior Court disagreed with us and held that basically what they had said in that pleading was good enough to get past, that there was no defect on the face of the pleading, because what they said was somehow or another good enough to satisfy the pleading requirements. I think we can all agree that at its core is what the Superior Court did hold in this case. Hopefully, if this case survives, that's the limit of what the Superior Court held in this case, and all of these defenses that a party is not the legal owner to a loan can still be raised by virtue of a defense to a complaint if you can answer on time. And there you don't have to get to the issue as to whether or not the pleading was defective. Maybe they pleaded it well enough, but they can't prove their case because it's in fact not true. They're not the legal owner of this loan because until the assignment is perfected, there wasn't anything that made them the legal owner of this loan. They jumped the gun. And by jumping the gun, the complaint is invalid. So hopefully we can, I think we intend to still continue defending on that basis in every case that we can where we get a complaint on time. There are some sort of suggestions in here that the Superior Court may not have really understood all of that, and I guess it's unclear whether they meant more than what than my reading of this decision. And all I can say is that if this decision survives, let's hope that all they meant was what I just said. I don't know if there's anything more that we need to say about Mallory.
I would like to say one more thing about Mallory. There are two ways by Pennsylvania law to undo a default judgment. One is to strike a default judgment, but you can only look at what the written record shows to argue that it's wrong on its face, and you can undo it. But the second way is a petition to open a default judgment. And
we tried that here in Mallory also. But we filed this so long after the default judgment had been entered that the court basically said, sorry, it's too late.
And my point is that the Superior Court not only didn't, the Superior Court specifically said that perhaps if this particular plaintiff had this particular client, the defendant, had come to court soon enough to be able to make a petition to open the judgment timely, then we would have considered your argument. So if you have a client that comes with a default judgment, and it's very shortly after the default judgment was entered, and if you want to make an assignment argument the way it was raised, I believe that Mallory would not prohibit you from doing that under the petition for opening judgment law as opposed to the motion to strike judgment law. So I believe that, and again, it's still available if you don't have a default judgment, you can still make these assignment arguments.
Do you think that a preliminary objection is undone by the Mallory decision?
I think one can object to lack of standing based on the factual question as to whether the party that filed this lawsuit has standing. I don't think that, and that can be raised, I believe, by preliminary objection, unless somebody will correct me on that. I don't think that one can raise a defect in the wording of the pleading or in the lack of averments in the pleading as to the basis for that standing, but I think one can still complain that there is not standing because the plaintiff is wrong that they're not the owner of the mortgage. Does that make sense?
But you can still raise it as an answer.
Mm-hmm. Yeah, I'm just wondering whether or not if Mallory stands and is not undone by whatever re-argument or reconsideration is given, whether you lose the ability to say that the plaintiff did not hold the assignment at the time the suit was filed, therefore, I don't have to answer this complaint.
I think it depends on what the wording, what the language of the complaint says. This particular paragraph upon which discusses in that complaint is so far the only law. There's only one law firm that uses that particular language, and it's very obtuse language. But most of the other complaints that I have seen are pretty specific about what they say. The recording, the assignment was done on this date, it's recorded there, the assignment was done on that date, and you can still raise some of the things I was talking about, and then you could argue in preliminary objections, but I actually, there's another, whether you should or not, as opposed to answer something else. But in any way, so far, there's only one law, Friedland and Hallinan are the only law firm which uses this particular language. Watch out, though, there may be other law firms which will now adopt the language, and then you'll have to deal with it.
I think as far as the current state of the law is with this decision, if it stands, is that their pleading is specific enough to get past the specificity requirements of Pennsylvania pleading rules. As to whether substantively they're correct that they are the legal owner of this mortgage or not, that can still be raised. And again, I'm not real clear right at this moment as to whether one can raise that by way of preliminary objection or whether that has to be raised by way of an answer. You can, in preliminary objections, raise certain factual disputes. It's not just based on the face of the pleadings. So if that's something that you can raise, the lack of standing, then I think it could still be raised by preliminary objection. And then you get into a sort of a pre-answer dispute over whether there's whether that averment is correct. Yeah.
Just out of curiosity, how long after the default judgment had been entered was the motion filed?
Only about 5 years.
Oh, no.
82 days.
It was
82
it
days.
was, yeah, and to me, one of the unfortunate things about this decision is that it cites, it uses 30 days. I think it implies that longer than 30 days could be a problem because it mentions that all of the cases that they looked at where judgments were allowed to be open were less than 30 daes.
Actually, though, the cases are all over the place.
The cases are all over the place.
And I think what that does tell us is that the judge who decides this initially probably has the discretion to decide it, whether it's longer than this or whether it's shorter than this, and that's not going to be reversed by the Superior Court.
But I would expect to see in response to our petitions to open judgments, the other side citing this case that it's got to be 30 days. Yeah. And if it's longer than 30 days, it's too long, which to me, within 10 days, you're within the rules of procedure to open it without an issue at all as to anything but the meritorious defense. So now, if 30 days is the outer limit, we've got a 20-day time frame, and our clients don't get into us that way.
But just to argue against what Beth's saying, there are some fairly bad facts in this particular case as to the number of occasions in which notices were sent to this client saying you should see a lawyer, you should do something about this. And in fact, there's even some bad facts in there as to how much time it took from the time that this client did come into our office to see us before we filed the petition to open. And one can argue against this 30-day requirement by pointing to those particular features of what happened during those 82 days in this case that perhaps didn't happen in 82 days in your case. Yeah.
Do you think, or why do you think, if that's specific to mortgage foreclosure complaints, because I filed petitions to open and strike regular consumer credit card cases much, much longer than that, and it's worked. So do you think it's going to be just for these mortgage foreclosures, they're going to do this 30-day where we can go in on a credit card 3 months later and it's working, or?
I think the cases are so much all over the place that hopefully what this means is just that whatever the judge who decides this is not going to be, based on the circumstances in that particular case. I hope.
And hopefully your judges at the trial level will continue to do what they've been doing if they've been granting.
Unfortunately, in this case also, there were extremely strong substantive defenses to the foreclosure that had this judgment been stricken and had we been able to raise them by virtue of an answer, hopefully would have prevailed. And really hope that the Superior Court would look at those strong substantive defenses and minimize the amount of time that it took to file this as a result, and they didn't do that.
Do we know for sure that Mallory's going to be published?
Yeah, I think so.
It is going to be published. I saw that it is.
If re-argument is granted, it gets vacated, but, that's our hope.
May I do a little bit of notes? Or no?
Yes,
All
well,
right.
I do want us to go back for a few minutes to what happens with notes secured by home mortgages in the securitization process when you end up with this trustee as the plaintiff in a foreclosure. And do keep in mind, even if you don't get all of the details, that there have been several transfers of a note and mortgage by the time it gets to the plaintiff that's identified in the foreclosure. Or if it's pre-foreclosure, know that the company your homeowner is dealing with is not the owner of the loan. They're dealing with a servicer. And I'm going to talk in a few minutes about how you get information out of the servicer to figure out who does own the loan if you're starting to think about a foreclosure defense coming up. But Eileen is going to talk about the notes themselves, and then I'll talk a little bit more about what happens to them after they've been executed.
Remember that the right to be able to sue to get somebody's house for a default really comes, what's the default? It's even though everybody alleges, the plaintiffs always allege a default in the mortgage wasn't the document that gave the client the loan. It was the note. The loan document itself is the note. And so the question then is, what evidence is a plaintiff required to produce, and first of all allege in the complaint and then produce at trial to prove that it owns that loan itself? There are no appellate court cases. I'm not even aware of any lower court cases in Pennsylvania that deal with that issue. Again, there are really good cases from other jurisdictions, and especially in bankruptcy courts. There are quite a number of cases that require that the plaintiff has to show that it owns the note as well as the mortgage. Or in fact, you don't necessarily even need the mortgage to be able to sue for a default if you have the loan itself. The problem with Pennsylvania, which might make this a more difficult argument to make, and by the way, I would say that I've never seen a complaint, I bet nobody here has ever seen a case where initially you get a lawsuit where it has been alleged that the plaintiff owns the note. And that is because the Pennsylvania Rules of Procedure, which prescribe what is required in a foreclosure lawsuit, don't mention the note at all. And it prescribes what must be contained in the complaint, although it also refers to the fact that all the other rules of civil procedure must be complied with as well. So in that, indirectly it would. But those few rules, 1141 et sec, don't mention note. It would be my contention. The contention of those who do this kind of law is that, in fact, in order to be able to prove that the plaintiff has a right to a foreclosure, they have to prove that they own the note. And one way you could raise it in preliminary objections is that if you read the mortgage, but the mortgage doesn't say what the terms of the note are. All the mortgage says is there's an amount of money that's owed and it's secured by the house. So that in order to be able to prove that there's a default, you have to be able to prove what the terms are that were then defaulted by the defendant. And in every single mortgage, there's a reference to the note. So what I have recently begun to do now is every time there's a complaint that comes in, I file preliminary objections to say the mortgage refers to the note contains the terms of payment. You can't prove default unless you prove the terms of payment. Rule 1019 requires that all documents upon which the plaintiff relies must be attached to the complaint, and therefore the complaint fails because it doesn't attach the note.
Let me just insert something, and if they get around this by saying the mortgage has been recorded and is of record, and they can incorporate the mortgage by reference in that way, the note, however, is not part of what's recorded, so it can't be incorporated by reference in this way.
Right. Now, I don't know if anybody here has had any challenges to that preliminary objection. I've always had, my plaintiffs always then file an amended complaint so far with the note. But that's the first step that I take, and I think we should all take whenever we get this case, is one of those preliminary objections should be failure to attach the note. One of the reasons that's so important is because there are estimates that of the billions the millions and millions of mortgages that have been securitized, at least a third of them, though the trust companies don't have those notes and will not be able to find them. And so the argument that we believe should be made is that if the plaintiff cannot produce the original, and by the way, the UCC requires the original note unless you can prove by a number of ways that it's been lost and you've tried to look for it and can't find it, the production of the original note. And if the plaintiff cannot provide evidence that it has that original note, not just a copy of it, then the plaintiff cannot win in a case, even if they have a proper assignment of the mortgage. There are cases in other jurisdictions that are in the materials that discuss that and say that that's exactly a proper analysis of the law. Yeah.
I'm sorry, the rule you were referring to, the 1019, says either attach or explain why you don't have it, and they may be able to explain why they don't have it.
Right. And
explain again
okay.
how that doesn't get them past producing it
No,
later on.
I think
The explanation is that I lost it, not that I can't prove that I ever had it. If the best you can say is I can't prove I ever had it, you don't fall under the lost note defense. You have to be able to prove I had it at this point when the loan was originally transferred, but since then I've lost it.
And some of this stuff might get them past the pleading stage if they plead something like that, but what they plead might turn out not to actually be true.
Okay.
Okay, so the one other thing before and that's going to talk about how you try to when there's all these secured trusts that hopefully maybe they won't ever be able to produce the notes. How you can try to find out who has that note in that case. One thing though so I'll pass this on very quickly. But the one thing that I've seen in many of my when I'm looking at the assignments, is that the assignment says in it, this assigns the mortgage and the note. And I don't know if there's case law on this, but at least the Gardner Guru points out that those are two different kinds of documents. And a mortgage is an assignable document, which there has to be signatures on both of the S&R on there and the S&E. Notes are negotiable instruments like checks, and you don't have to put to whom the note is going to be, who owns the note on it. That's why, actually that's one of the reasons why it's so important that you have to possess that note. But at the same time, because of the differences between notes and mortgages, a note cannot be assigned. There is the only way a note can be conveyed is by delivery. And so if there's a purported document that says this assigns, and many of them say this assigns the note as well as the mortgage, then the argument has to be made is that that's invalid under the UCC. It's another complicated issue, but I think it's, and also because judges are in foreclosure cases, they aren't used to thinking about notes as being part of how important a note is to being able to prove a case. But if we start to raise these issues, then they will become something that the judges will recognize. Hey, you can't go ahead and sue when you don't have that note.
And one place where this will be particularly important is where MERS is somehow or another involved in the mortgage. MERS, M-E-R-S, is the Mortgage Electronic Recording Systems, which is apparently an office somewhere in Virginia of about 10 people who purport to have been, to hold, 3/4 of the mortgages in the country. It's a mechanism by which lenders and assignees and servicers and whatever try to avoid having to record transfers of the mortgage by either making it out in the name of MERS or having it assigned to MERS and then holding it there until they are prepared to assign it to the foreclosing plaintiff. MERS purports to be either the mortgagee or the assignee of mortgages, but they don't purport to have any relationship to the note. In fact, they do not ever hold the note. And MERS is not able to transfer an interest in the note to or from anyone because it doesn't have anything to do with that. I don't know if we're going to get more into MERS at some further point in this discussion.
I think we probably shouldn't. What I think is if you are litigating a foreclosure case and MERS is the plaintiff, contact one of us and we can talk to you more about how to deal with that in defense. We've spent a lot of time on this issue, and I go back to the idea that what I look for in this issue is the ability to level the playing field, especially for clients who've been victimized by awful predatory loans. You guys on the lending side threw all the rules about lending out the window and made horrible, unaffordable loans that were destined to foreclose. Well, then I'm going to make you follow the letter of the law under the UCC if you're going to try to foreclose. And we're at a standstill. My client owes you some money. You can't foreclose because you didn't keep track of the paperwork the right way, so let's make a deal. That's, I think, what we're after in raising this issue.
And I think one of the key things just to remember, I always used, the boilerplate allegations to the plaintiff, so-and-so is the plaintiff, so-and-so is the defendant, blah, blah, blah. I always used to admit all those things and then only get to later on where they were just, the amount of money that was owed, I might dispute that, or I might give some affirmative defenses as to why the foreclosure shouldn't take place. I think it's important now when they allege that so-and-so is the plaintiff and has rights to the loan under blah, 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 you don't want to ever admit that anymore. And at least deny it on information and belief and put them to their proof that they really do hold the loan, that they really are the assignee of the loan. And then do discovery on it to see if they can really come up with any proof that they're really the party that has a right to bring this action.
In the materials on the disc, there's an excerpt from a memorandum of law in response to a summary judgment motion that I did in one of my cases where I raised this issue. And you could read that as sort of background in how these loans get transferred within the securitized trust, and how you might raise it by trying to go to the SEC website, pulling up the actual pooling and servicing agreement and pointing out that this can't be a simple transfer, because there are so many variations of how the foreclosure plaintiffs are trying to get around the essential problem that they didn't transfer the notes properly and didn't execute assignments of mortgage at the time that the transfer was made. 20 years ago, you're defending a foreclosure, loan was made by A, assigned to B. The assignment was executed and recorded at about the same time that the transfer was made. And there was really no issue there because it was all done at about the time that the transfer was made. In these cases, in the frenzy of subprime mortgage lending, the lenders and the Wall Street banks made a decision that it wasn't worth paying enough staff to get every single note, stamp it with an endorsement, and have somebody for the originator sign an assignment of mortgage. And because of the complicated setup that they created, they would have had to have done that 4 times to get it properly into the trust. They made a conscious decision not to take the time and spend the money to do that. And they weren't anticipating the level of foreclosures, and now they got a problem because they don't have an assignment until just before the foreclosure is filed because they made that decision. So just know that this is going to be an issue in a lot of cases. Know where to look for the information you need to raise the issue, and don't, as Peter said, give them a pass on those averments in the complaint that say we own the loan. And I think that'll be our ending point on this subject.
Do you have discovery models on this?
can't remember if I included one in the materials that are on the disc. But you know, I think they are on the plan website from an earlier version of this training, and if not, you can get them from us. I think we at this point have all submitted discovery requests. Basically what you're asking for is the original note with all endorsements that lead it to the current plaintiff, that make the current plaintiff the owner, the plaintiff in the foreclosure, the current owner of the note. It's not actually that complicated a request.
Although in my cases, at least, I got to be prepared for a fight because I don't get it.
Okay. We are probably getting close to the start of the last hour. I've lost track of time, but this 2-hour session was titled Assessing Cases Pre-Foreclosure, Getting Information from the owner of the loan that you might want to get both in resolving disputes about how much is owed and maybe in tracking down who the owner really is in order to set it up for a foreclosure defense. We also wanted to then talk a bit about how bankruptcy plays into all of this now that there are so many other options.
Remember bankruptcy?
Yeah. Bankruptcy got a bit harder because of the new law, and then bankruptcy got a bit less relevant in my cases because of these other options, now including HAMP, that are out there. Once you've filed an answer to the foreclosure, maybe your client is not going to ever be able to get caught up on the current loan, but maybe she doesn't have to because she can get a HAMP modification. So we're going to discuss when would you use bankruptcy these days.